limiting how people can actually access health care, you do start running into some of the court's privacy decisions. Indeed, as suggested in the abortion area, the court has carved out virtually the only absolute right in the Constitution, more absolute certainly than the right to free speech and religion, at least as the Supreme Court has interpreted those privacy cases. But it's true. It can't just be for that. If you have a right of bodily autonomy, it's the whole thing. It's not just that particular aspect. And it would be very interesting to see how the court would adjudicate such cases, both under its privacy cases and under, from my perspective, more legitimate substantive due process cases that do suggest that there are certain things the government can't do to you. It's not very well defined, but making it impossible for you to get needed medical care, that's going to have a really good argument that that's one of those things.
I'm actually amazed that so many women's groups have supported this law, obviously without reading it, because I remember when Gloria Felt from Planned Parenthood in 2004 said she was applauding a court decision regarding the efforts of the federal government to ban partial birth abortion, and she said, you know, this decision is so important because it makes it clear that doctors and patients, not politicians, will be interfering in our health care and accessing our medical records. And here they are supporting this law, which makes it so clear that the federal government will be doing both.
Well, I could imagine a conservative politician creatively thinking of a way to effectively outlaw abortions as a result of the federal government's role in providing health care coverage through either state exchanges or elsewhere. There are opportunities for those who support liberal progressive policies on these issues to really lose out in some of these health care debates if conservatives decide to exercise the powers that are given to them through Obamacare.
I think that's very true. I don't know that I can elaborate on that, but that's very true.
Yeah.
Well, one of the most amazing is in this recent discussion over contraception. Contraception is not guaranteed as an essential benefit under 1302 of this law. The Secretary of Health and Human Services, a presidential appointee, is given the authority to decide what must be covered under health plans, and a future occupant of the White House could say no contraceptives. Why would anyone want their decisions about their insurance plan to be left to the whim of whoever is president at that time?
Can I jump in here, Betsy? I know John Fund and others want to ask us questions. I've seen their hands going up out there, Tom. But I do want to elaborate on this one point. It brings up the issue about the contraceptive. It's under the question of the mandates of what's in an insurance policy. And you've talked about it a couple of times, but I want to be real explicit because I've come from the state's perspective now. And there are in Florida, I think, still about 60 mandated coverages in any basic health insurance policy, which is one of the great problems in politics, is that in studies that I've been involved with and I've chaired and so forth in real health care reform, what do we need to do, what are the problems? One of the top problems is the fact that you could reduce the cost of insurance policies considerably if you didn't have all these interest groups lobbying the legislature and getting everything put into a policy, and then having so-called insurance companies, they aren't so-called, they are health insurance companies, wanting to keep them there for reasons that say, why do I need to have certain maternity coverage if I'm a single male? Why does that need to be in the policy? Or whatever else it may be. So I always thought that it would be better for the states to be realistic about this and say, okay, there are 10, 12 things that ought to be in a basic policy, and everything else is like television, you know, cable or whatever. You're going to go buy and you get a menu and you can pick and choose other alternatives and pay a little additional premium for it, but only a limited number of things in a basic policy. Now, the federal government's come along for the first time, and when I was in Congress, they didn't have any of these powers. They maybe have them, but for the first time, they've come along and they've said, we're going to regulate insurance. We're going to decide what's in a basic policy, but they didn't preempt the state. The states can still have those. So what's going to happen and what's happened with the contraception, to me, the argument is not just about abortion or your views on life and choice and all. It's about this usurpation, this deal that's going on, and it affects this case. It's not being argued. I don't think it's in the briefing. But I would have loved to put it in there if I'd had it in my mind, or I could have convinced Paul Clement earlier or whatever. I did talk to him about it, but it's not in there. In any event, the truth is that I discovered from our Department of Insurance in Florida one day in preparing for one of these talks and asking them some unrelated question. They had just sent a memo over to the state legislature and said, hey, there's a huge hidden cost in the Affordable Care Act to the states. Because there's a provision in there that says that if the federal government has issued, say, 15 or 20 mandated provisions, then let's assume for the sake of argument they're all identical to ones Florida already has. Well, let's say 20 just to be simple, and Florida has 60, and I don't know the exact numbers. Let's just use them as illustrations. Then the state of Florida, unless it repeals those additional 40 mandates, is going to have to pay money into the federal government to compensate for the additional Medicaid costs that the federal government is going to have as a result of all of what's going on with these additional mandates.
And the insurance exchanges, too.
Oh, and the insurance exchanges, too. But this is just one illustration of how devious this is and how much more costly this can be to the states. Now, granted, in this case, probably the reason the argument's not being made to the court is it's pretty clear if the states wanted to, they could repeal all of those. But you know and I know they're not going to because of the politics. So this is going to become one, maybe they would repeal 10 of the additional 40, and you still have 30. I don't know what the number is, but it's still very expensive. It's just an enormous nightmare to the states.
Okay.
And it's because the federal government is choosing to usurp a power historically left to the states.
Well, let's allow the floor to participate here. I think we have a microphone. John Funn.
I went to a panel discussion with your counterparts from the other side discussing the Supreme Court issue, and they've obviously spent a lot of man and woman hours in researching this, and they claim to have found their silver bullet, which is that in 1792 under President George Washington there was some kind of mandate to the states that they empower a militia and that the militia be equipped with a flintlock and various cartridges and the necessary and proper equipment
yes.
to repel foreign invaders. In other words, it's a form of servitude that they were requiring. And I'm just wondering, have they found their silver bullet, or is it lead?
I'm afraid, like the balls that were shot out of those muskets, it's lead. There are indeed certain things that the federal government can require individuals to do. They are few and far between. The Militia Act is based on a specific grant of authority. I mean, there is an enumerated power that allows Congress to raise and support armies and to regulate the militias. And that specific grant indeed supports that kind of regulation. It wasn't the Commerce Clause. And I mean, I think that is the key. They're mixing and matching powers, and they can't do that. I should also say they also raise often other examples. For example, the federal government can require you to serve on a jury, as can the states. And it's true, there is no specific provision in the Constitution that permits them to do that. But that is one of those few things where the Constitution does permit them to create courts. And from the perspective of the framers of the Constitution, when they said court, they didn't just mean a building. I mean, they meant all of the attributes of a court that they were familiar with. Jury service was one of them. And indeed, so is militia service, actually. These things go, as they used to say, time out of mind. There are were obligations of citizenship that are easily inferred in the Constitution, and indeed, certainly the military service, when the court in 100 years ago or so upheld the draft for the first time, it very specifically said, look, Congress can raise armies. What do you think that meant? I mean, of course they can impose a draft. That has been the case for the last 800 years. And so I think when you start trying to come up with these other examples, find me an example under the Commerce Clause, which is what is at issue here.
I'm looking forward to a presidential candidate running on a platform requiring citizens to have guns. That would be a great one. Any questions, comments?